Hey, everyone. My name is Andrii, and I'm a partner in the company called Potent Partners, and we focus on contracts, GDPR compliance, personal data, consulting, and so on and so on. So today, by the invitation from Sputnik, how's correct English name, we're going to talk a little about personal data and marketing and some of the issues that you might want to learn or you might already know. Actually, just going to rehash them a little bit and then discuss what are some of the key stuff that you should be familiar with when you're working with data if you're affected by the GDPR or similar laws. So the first thing you have to worry about when you're creating when you're actually processing any kind of data is to understand what is the lawful basis for such processing. So, and if you've already familiar with GDPR, even a little, then you probably know that there are a couple lawful bases to work with. These are consent, contract, legal obligation, vital interest, public task, and legitimate interest. So some of them are useful and actually needed for you as a company which does direct marketing. Some of them are absolutely not essential for you and you're probably not going to be using them. So we'll go and look at each one of them. So a consent is when an individual has given you clear consent to process their data for a specific purpose. And a specific purpose is a really important word here because you can only process that data when he has given consent for a specific purpose. So let's say you cannot process the same data that person has given you to receive the service, to send him direct marketing emails promoting, for example, your partner product or a company that you're working with, because that's going to be an overlap of purposes. So the next one is contract, and that's the processing which is necessary, like a lawful basis where the processing is necessary for a contract you have with the individual or because they have asked you to take specific steps before entering into a contract. So that would usually be something like when you register for a service, you have to give them an email, your name, your phone, or some other data like, you would give an IP address to be able to receive that service. So in this case, basically, the amount of data necessary to receive the service should equal the amount of data that you're basing your the data that you're using on the lawful basis, on the contract lawful basis. So for example, I use Uber, and Uber really needs my location, my phone, my name and email in order to register and get the cab where I need it. But it doesn't, but when I use it, it doesn't mean that I'm giving it consent to send me some other type of information necessarily, which I haven't consented to or do not receive a service. So these two will be some of the more common lawful bases that you're using when you're doing direct marketing in your company. This one, legal obligation, is where the processing is necessary for you to comply with the law. This is something that is going to be pretty rare, and there's probably I don't know about cases where you have to collect data for marketing, for direct marketing, especially like when it's actually a legal obligation imposed on you by some country. So that is very unlikely for you to happen. It might happen where you have issues when you have to store data as a company. For example, you might be a medical company or a service which is obligated to store data for a certain amount of time. So that's where the legal obligation might kick in. The next one is vital interest. And the vital interest is processing is necessary to protect someone's life. Again, probably a very rare lawful basis to use for you because you're very, very unlikely to end up in a situation when you have to use direct marketing to save somebody's life. So it's probably not the one which you focus on a lot. Again, public task, unless you're a government agency and you have to do this in case of your public tasks and duties and prescribed by law and so on. Probably not going to need that. And then legitimate interest is where data processing is necessary for your legitimate interest or the legitimate interest of a third party, unless there's a good reason to protect the individual's personal data. So basically what it's saying, it's not as clear as consent. It's something that where you have to value and consider the interest of your company and the individual whose data you're using. So basically you compare them together, and then you can understand like whether such usage will be in the user's interest. For example, direct marketing can be used on a lawful basis, under a legitimate interest as a lawful basis. So let's say somebody writes to us and he registers for a service and he starts using it, and we believe that this person specifically might be interested in some letter or some information that we're selling because he expressed his interest. Most of the time you would need consent for that, but sometimes you can evaluate and see that legitimate interest will be the correct approach. And then if you use legitimate interest, you don't really have to get consent. Sometimes it's so it's really affecting the screens, the amount of screens that you have, the amount of clicks that the person has to do, the amount of text that they have to see. But at the same time, so you're putting the expenses from the individual and actually have to do more inside your company to evaluate whether such use would not violate his rights. So we could go for a couple examples, and if you have any ideas and cases on how you're currently using the data or how you're doing your marketing activities and you have questions, you can just send them in the YouTube chat, and I'm gonna try to go through them in our table below. So for example, like a couple of simple cases, right? So we collect some information when a user signs up for the website. When he signs up for the website to just use the service and to receive whatever he, whatever the reason he subscribed to the service. Let's say right now I'm using Notion, which is an amazing product that I love. And when I download Notion or when I go through the browser, it asks me to log in. I log in using my Google account, and also it asks me for a password. After that, it asks for some more information about me, like who I am, what I do, and so on. It's not necessarily personalized information in their case, but the main info that they get from me is my account or an email and my name on, to just have my account set up. So in this case, the most appropriate lawful basis would be contract. It's not consent, right? Because I provide this data in order to get the service. So if I stop using the service, I just delete my workspace and it's out, and I send them a letter and saying like, stop using my data, thanks, it was nice. But you don't really need consent for that, which a lot of people get confused about it, where the sign up page is usually a mix of direct marketing consent and login page. So it is convenient, but it also tends to confuse people as to what exactly they're getting right now, because many people believe that when a user is signing up for a service, they're actually giving consent for the service, and the consent would be a lawful basis to process their data. Most likely, it's your contract with the user. So the next thing where it would also be essentially connected. So for example, once I've signed up to Notion or stuff like that, I want to receive updates about the service. I want to understand what is happening. Am I being billed correctly? Am I being, is there something changing? Are there any updates and so on? So most most likely okay with getting service emails, which would also be a part of the contract and not my consent in this case, because I would get, basically I would receive this information as a part of my sign up for the service, because I still want to have it as a product, understand what is happening, and so on. Okay, so it becomes different for direct marketing, specifically due to the general data protection regulation and the previous e-privacy directive, and is going to be probably another e-privacy directive later, as well as some local laws in different parts of the United States and different countries and so on. So for example, if we do want to promote some of our products or like different products, or we want to say that, how about you buy this or upgrade to this kind of product and so on. When we want to promote, then we probably need to rely on consent. This would mean not the service emails, so basically a user is not getting necessarily anything from the product itself, and we're trying to upsell him or cross-sell him or give him some additional information that we believe is going to lead to some kind of sell later, so on. And we want to send him emails or push notifications and so on. So in this case, we would need to rely on his consent. And the best way to do consent in this case would be a double opt-in, where when the user clicks, he enters his information on the sign-up page, then he clicks, yes, I'm okay with the terms of use and so on. And then he also clicks, yes, I'm willing or I don't know, I'm happy to receive marketing emails. And he clicks that, he receives an email, and then he clicks another link in the email itself to confirm that he does want to sign up. And that's how it works best, because otherwise people tend to, sometimes they don't understand and they get swarmed by emails, which in the end they actually don't read because they have too much. Basically, this is one of the best ways to ask people for consent and to receive it. Another simple case, so we want to personalize our marketing email to the user and give him better recommendations. So in this case, we'd probably be gathering email and some preferences. So for example, something that the user has browsed previously, something that he has seen, something that we have tracked from his behavior and understand that we might want to offer him. So in this case, you would also likely would need to rely on consent. There's still an option in both these cases, actually, that you might be able to rely on legitimate interest as your lawful basis, but you would need to do a lot of research to be able to convince your company to make sure that the legitimate interest as a lawful basis would be okay for you in this case, and it's not risky. Because the thing is, you cannot switch lawful basis midway. You can, but then you have to explain why you did it, and then you have a lot of explaining to do. So basically, it's a lot about preparation, understanding what kind of information you have, how you're going to use it, what are you going to do with it, how you're going to delete it, who's going to get access to it, and understand which lawful basis works best from a user perspective, right? So what does the user expect? Should he have the ability to unsubscribe from this, or control how he gets his notifications and so on. So coming from a legal field, my perspective is that more control is good if you're able to provide it. I like it. I'm the kind of person who has switched off almost all notifications on almost all the services I use, except for a couple that I really love. And I love the fact that now I can actually do it much easier due to visible and simple unsubscribe links and emails, or some kind of admin boards where I can set up my preferences and subscribe or unsubscribe for a lot of them, where I can control easily which ones that I really need. And I specifically love companies who explain what kind of information I'm going to get there. Because if they don't explain, I'm probably going to unsubscribe. If they do explain, I might take a couple of boxes that I believe are better or more suited for me. Okay, so and the important thing is, so once you have set up a process, and you can have essentially almost infinite amount of these processes here, you can look through all kind of data processing that you do in your company. You choose the lawful basis, and then you try to stick with it for a long time. Another reason why you might want to, be very conscious about it is that consent is very flimsy. So yeah, you might get consent by, providing somebody with a good information or something like that, where he has to get his email and download something to get and subscribe to your email newsletter to get something. But at the same time, this person can still, he has to have an ability to easily revoke the consent that he has given, and you have to give him this ability. It has to be really simple for him. So often you might want to look at other options that you have, such as contract or legitimate interest. If you really need some kind of information for your service to function properly, you might be able to explain it through those means and not just consent, because consent, it comes and goes, basically. Okay, these are some of the basics of the lawful basis for gathering consent, and we're going to move to our next topic. Yeah, so basically, whenever you're gathering any data, I know there is this common approach is basically the more data we have, the better. We'll find out what we need to do with it later. And a lot of the clients that we spoke to before the general data protection regulation, when we asked them, how long do you store the data? They said forever. And what do you store? And they would say, I don't know, like a lot. So basically the GDPR cut through that and said that you only should use data that is relevant and only the stuff that you really need. So coming back as the thing we described previously, so you have an Uber app and you want to use it, and so Uber does need your phone number, your account, or maybe a location, and that's the key information that it needs. It doesn't need your gender, it doesn't need your political affiliations, it doesn't really need your skin color, whatever. It doesn't necessarily have to have a photo, and so on. So it can have them, but then they would need to use the lawful basis, the correct lawful basis. And still, even if they're using the correct lawful basis, such as consent, they would need to explain why they need that, like why this information is useful for them. So the core idea right now is to have only the information that you actually need, strictly necessary for the purpose, right? So one of the most common things would be like all kinds of data that you need for the service to function properly. Okay, and then the next thing is then when you gather that data and you have a minimum amount that you have, you must only collect it for a specified, explicit, and legitimate purpose, and not use it for new and incompatible purposes. Again, so let's say I get my Uber and I use it and I drive around and I gave them my email in order to get some service notifications or like bills back to my account and so on. And suddenly Uber decides, like, we already have this guy's emails, how about we start bombarding him with messages about how, and I don't know, Uber Eats is awesome, or like, let's say there's a new promo that we have that this guy should buy definitely. And most likely I never subscribe to that because I usually don't. And now they suddenly use my email that I gave them for, to actually use the app. And instead they started bombarding me with messages that I have not consented to. So this would be using the data that you already have for a new incompatible purpose. Some other examples would be, for example, I don't know, you're a political party or an NGO, and you have a lot of data on people who have joined your NGO. So they gave it to join the NGO. So like they have their information. You can probably guess their political leanings if you're a political NGO or something. You have their phone numbers and other types of information. And suddenly the NGO decides, how about we get some money? Because we need to promote the good stuff that we do, and in order to promote the good stuff that you do, you probably need money. So how about we go and sell this information to somebody? So again, this is quite an unrealistic example, but it's a silly example of what would be a new incompatible purpose from what you've been doing previously. So for example, if you would want to actually sell that data to somebody, you would need to go to the user and ask them, like, can we actually do that? Would you be okay with it? You can probably guess the result. And again, this is like a good mental exercise. If you see that like you have a new purpose to process data and you want to sell it, you want to use it somehow differently and so on, think about how would the user react if you come to him and ask him, are you okay if we do this? And if he responds no, then most likely you cannot use it. Again, check with the lawyers, check with your internal team, weigh the risks of using or not using the data, the cost-benefit analysis, etc. But it's a good first start to understand whether your new usage would actually be okay or somehow problematic. So, for example, and again, coming back to the type of thing that we discussed. So, for example, we get user data to be able to provide the service. And when we do that, we use stuff like email, name, maybe phone, and the lawful basis would be, and the lawful basis would be a contract, right? So this is our process. This is why we use the data, and the department responsible for it would be, I don't know, product department. Again, next case, we use email obtained on sign up to deliver service messages. Okay, still fine. We use email. Our lawful basis is contract, and we also have a product team doing this. And now we move to this new thing. We use email obtained and sign up to deliver direct marketing messages. It could be okay if you use consent previously. So you say you have email, and if you have if you have used consent and given the person a chance to actually consent to this kind of processing, then it's probably okay. But most likely you would, some people would want to use the data that they have already on the user. So like you already have a bunch of emails, but the lawful basis was previously contract. So you cannot just switch to consent here. You have to ask people for a consent on the new type of processing. And in this case, probably the marketing department would be responsible for this. So they would need to still work with that. They cannot just go to the product team and tell them, give us your emails, we're going to send a bunch of messages. But of course not, like you have to actually ask users for their consent. And the same goes, product team. They cannot simply use the data that the market is collected for some specific purpose that the user gave them to, I don't know, use it for the product or give it to a partner company or something. So only when it's allowed. Using personalized cookies, a lot of you have seen cookie banners and so on. So most likely in cookies, you would have to have consent. And that's the simplest way to go. It looks terrible, essentially every time. You have all these cookie banners. There are a lot of them, but like not much you can do with that about it. And again, so for coming back to the minimization term, part of the principles that the GDPR has. So let's say we have an app which is where, a service where we sell goods online, right? So we sell goods online and we need some data. For example, we would need to have an user email, name, phone, probably his address to deliver stuff. And I'm sorry if you can hear my cat who's screaming outside for some reason. He's fine, but So for example, you would need to have his address. You would need to have, what else? You probably need to process card information, not directly, but through a payment provider. Or like, let's say, payment information. So this would be a basic set of rules, basic set of information that you need to have. So, and something which, if you're working with minimization principles, the stuff that you would not add here would be, I don't know, again, race, religion, and those are protected types of data. You would probably not need the sex of the person, or gender. You would also not need, think about it. You don't really need to know how old the person is to be able to provide the service. You can ask that later if they gave consent, but here you probably don't need this information. So it would not correspond to data minimization principles. You would simply not be able to explain why you need this data to be able to sell somebody a toy online. Okay, and this would likely be contract. Okay, so these are some of the basics on data minimization. The GDPR has been in power for a couple of years now. It hasn't been too terrible. It hasn't been as bad as people thought before, because when it came into force, people expected that it's going to be just crazy and everybody's going to be bankrupt, and because of the fines, because the fines are huge. There are some big cases for the likes of Google or Facebook, but really in their terms, the cases were quite minor, and they're still not finally fine. They can still appeal a lot of that stuff. But there were some cases where companies have not conformed with the data minimization principles. For example, there was a taxi company who was fined 1.2 million Dutch kronas for non-adherence to the data minimization principle. And so the company had to delete the names of the passengers from all its records after they took a ride. So basically they had, the passenger had a ride, they took their name, and after that they had to delete it. But they did delete the names, but they did not delete all of the ride records, which was about 8 million trips. And they continued to hold on to phone numbers. Not sure where they were using them from, but they did have them, which was an issue from a data minimization point of view. So they got fined. There's a good service called GDPR Enforcement Tracker that you can use to see the key risks and enforcements that are happening right now, to understand if some kind of enforcement might affect or might not affect you, to understand what exactly are the risks, especially if you're working in legal field right now. So that might be useful for you. Okay, so something about push notifications right now. Basically, the current issue is with push notifications is, again, there are a lot of best and worst practices in push notifications in terms of marketing. in terms of how the users perceive it, how they act upon it, whether it's a useful tool, how it drives sales or conversion rates, and so on and so on. And I'm not qualified to explain that to you. There are way better people at this than me. What I want to talk about is push notifications and privacy and what we have in that front. And the truth is, we don't have much at all. There's no strict regulation regarding push notifications. There's nothing specific, really. Basically, push notifications are governed by the same rules as any other personal data. So if you are using personal data in your push notifications, then you have to conform with the same privacy rules. So let's say you want to personalize it, you want to, have direct notifications to somebody, and you want to say like, "Hey, Andrei, this is the thing that you recently saw. I think that you would love it." So this is probably quite a heavy use of personal data. So likely you would need consent for that, and you would need to, I would need to have controls over the kind of data that I'm using, and best if you do have consent for that. If the data is anonymous, however, it probably wouldn't count as personal information, because anonymous data is not personal data. It's that simple. So if you're using non-personal notifications, then there's basically no real regulation right now, except for good taste, best practices in the market, whatever gets the best results. How you want to approach your customer. Do you want them to be overwhelmed with them, or do you want to send them only the absolutely necessary information? Do you want to give them granular controls over what they get and how much and what exactly and so on? So basically, a lot of this is up to you. My only biggest recommendation as a lawyer right now is that while push notifications right now are not strictly regulated unless they contain personal data, if the industry becomes, if it overuses them, if it becomes an issue as it has become with like telemarketing often, or just tons of emails flooding people from somebody, or I don't know, if it becomes too aggressive, there will be regulation at some point. If at some point in time, countries and people and so on find that push notifications have become too intrusive, or they, overstep the boundaries of privacy and so on, there will be more regulation coming in, which might not be beneficial. So the better practices we use, the less invasive, the less bad they are, the better. And the thing that I would, emphasize here is that review the platform requirements, because they have them a lot right now, and basically just respect your user, give them choice, give him the ability to select, give him understanding on what is going to be signing up for when he uses push notifications, like how many, are there a lot of them, can I turn them off, can I turn them on only in specific times, etc., etc. I tend to just delete apps which have no controls for that, which spam me with messages. Like it often happens with, I don't know, various games on my Android. So basically I download them and then they start just piling up notifications like come back, play the game, and so on. I hate that. There are some also platform requirements. So as far as I know, Apple actually requires that you ask people for push notifications, so that they have to allow it, basically a consent mechanism, which I believe is great. That's how it should work. And Android, I don't think has that yet, but it doesn't mean that you shouldn't. It could be a good idea to have those mechanisms in place that the user can allow or disallow certain notifications in his on his phone to not be overwhelmed by them at all times. Okay, so again, basically push notifications are almost a wild field right now. Review the platform rules, review the best practices that you have, try to find something which is not as intrusive, respect the user, and should be fine. And if you do use personal data in your push notifications, then consider how and consider all the rules that are applicable to personal data. Okay, so here's a fun thing. Again, coming back to we're going to touch up on a couple things that we talked about previously about using data to process for certain purposes. So like when you process data, you have to have a purpose, you have to have a lawful basis, and you have to understand the data cycle that you have. So this is how we get data, here's the lawful basis for it, here's how it gets processed, and the security measures around it. And then at some point, we have to store the data or delete it entirely, right? So you have to be able to track your data through this whole process and understand what is happening for you in your company. Because users have the right to know about this. You have to be able to explain this whole process to them as well. And also they have the right to delete their data, to erase it. And although it seems weird and confusing at times, I know, but basically there are two main issues to this. Yes, you have to delete the data, but also you have to balance data deletion for your requirements and obligations to store said data. So for example, you had somebody who used your service, right? And he bought something from you. And he also has, he bought and you delivered something to his door. Perfect, that's beautiful. How soon can you delete his data if he asks you, right? So if he asks you, I want to erase my data, do you have to do it straight away? Do you have to do that, for some time? Who creates the ruling? So the answer here is that sometimes you have legal requirements and risks to take care of before you can actually delete the data. So if somebody has bought something from you, they essentially have a contract with you. It doesn't have to be written, but they do have a contract. If they have a contract with you and you have had some service, there's always a chance that for some reason they might want to sue you. You did something wrong, or maybe not, maybe they're crazy or whatever, but they have to have this chance. In order for them to sue you, you would actually have to have information about them to be able to understand what is going on and so on. So usually companies would store any data regarding purchases or users for at least 3 years, which is a very common measure for how long a person can go to court against you. So you would need to store the data for that time, and after that, you can actually erase it or delete it. So, which again, deleting data is usually impossible in a way, unless you want to destroy the servers that you have. So what people usually do is they just anonymize data one way, so nobody can de-anonymize it back, which is basically equal to have destroyed the data, because you have no access to it anymore unless somebody invents a quantum computer, but then that's a whole set of issues on itself. And coming back to the lawful basis and purposes, so for example, there are some basic reasons, like cases where somebody can request to delete their data. So the data are no longer necessary for the purposes for which were collected. Let's say, as in the case with a taxi, where they collected the data, they provided the rights, it worked, it was fine, but then they retained the numbers. they didn't really need that data anymore. So they had to delete it after 2 years in that case. So this is one of the examples. Another example is when the person withdraws their consent and you have no other legal basis to use the data. That's another valid reason. In most cases in life, you would actually, so you would often ask for a consent for stuff like, if we're talking about direct marketing, you're going to ask for stuff like email, name, surname, some preferences, and so on. You would also probably have a lot of this data based on the contract you have with the customer. So when they're asking to delete their data for marketing purposes, it basically depends on how you store that data. You don't have to delete the data that you're still using to provide the service, but you might have to delete the data that you're using for direct marketing. If it's the same database and you just have fields that tell you that we can send or not send emails and so on, then you just check that box and you still retain the data for the purpose that you have. Otherwise, you have to delete it. Yeah. So the other case where a user objects and there is no overriding legitimate basis for processing, and that's a tricky one because in my experience, people don't really object to data processing as often as it might seem. People do use consent a lot and revoke consent a lot, but objection is pretty rare. So in this case, if they do object and you have to review if you have a lawful basis, and for example, if the user has revoked consent and he also has stopped using your service, and the time for you to store the data for 3 years in order, if not to get sued has also expired, then basically you don't seem to have any good reason to store the data anymore. So you would have to delete it. That's how I would go about it. It's basically a question of reviewing what you have, how you use it, and why. Yeah. And in other cases where the data has been unlawfully processed, this is a simple dumb example would be where somebody buys off just a list of names from somebody else. They do have a contract with that person. The company that sold the list might have a contract with the end user whose data they sold. But in the end, you don't have that right. So you cannot use that data. So you would have to delete it because it was probably processed unlawfully. Again, which is not something that happens that much. But especially in big companies which share a lot of resources and data and users, it might be an issue to separate the processes between them. And again, so before you delete all your data, actually, like when you're doing internal process evaluation, you always have to understand on how long do you have to store the data. And by have, I mean that there's some requirement in law that you have to store the data for some time, for example, 3 years, 2 years, 10 years, 15 years, and so on. Could be for tax forms, issues, etc. And our question is, how long do you want to store the data? And that's where you have to evaluate what is the lawful basis for you, how you have informed the user that you're going to store the data and how long, how he can control on what you do with it. If you can, you can do whatever you want with it, you delete it, or you use it only as permitted, and so on. So basically you have to go through a couple of hoops to understand how long you have, how long you want to store the data, to make sure that you have a lawful basis, that it's fine, that and that you're getting the best information from that the data that you're actually storing. And again, always ask why you even need this information, because you might not need it. And if you don't need it, and if you can't explain to yourself why you need it, then you will not be able to explain it to any other lawyers or companies that come for an audit, or your investors and so on. It might be an issue. So if you cannot explain why you have the data, you probably shouldn't have it. That's the key rule. So GDPR is not really, as well as other privacy laws, are not really that hard to understand. But basically, you have to be able to answer why at every step of the way. Like, if we're processing data, why are we using consent? Why are we using this specific set of data? How we are using it, how we're protecting it, and so on. How we approach the clients if they ask us what we do with the data. And basically, you always have to be ready to respond to any of those questions. And that's how you prepare. There's not much more than that. And yeah, and that's basically it about some of the key issues found in marketing. I understand that this is not even close to covering everything because it's impossible. And another thing is, which is super important, when you work with privacy, there are a lot of context-based issues where you have to evaluate carefully the specific process that you work with. You can do it like with internal lawyers, external lawyers. You can do it with somebody who's not specifically a lawyer, but has knowledge in data privacy laws, which often would be someone who works in data security, for example. And using that knowledge, you can go through your processes, understand, and make a decision on how to properly use the data, notify the user, communicate with them, and so on. So also watch the news, see what happens, check if somebody gets sued, and if they get sued, if it's the company that is doing the same as you are, that might be a good time to notice that something is wrong. On a side note, right now the GDPR enforcement has seemed to slow down, mostly because of the coronavirus thing. Because basically they are now focusing more on companies which are covering everything related to the coronavirus, medical data, sharing of that data, notifying that somebody has been sick, and so on. So some of the regulators in different countries have said that this is now the time where they will focus on everything related to coronavirus and medical data, and everything else is not necessarily as much a priority as before. Okay, so there's a question in the chat. What are your privacy predictions for 2020, 2021? Do we expect to see more state-specific laws like Ccpa or private initiatives by browsers like Quieter Permissions UI? I think, so in terms of Ccpa and our state laws, most likely. The thing that I'm not a big fan in US in terms of regulation, that it tends to become a disjointed mess where you cannot really understand what to comply with. And it's really hard to evaluate the risks this way because the laws are so fragmented and so complicated at times. And Ccpa itself was a pretty rushed document comparing to how much work was put into the general data protection regulation. It looks like it's been done overnight by a drunk student. It's my opinion. And it's created a lot of confusion among the companies and so on. So I really hope that the companies will not copy the Ccpa and instead look at something more robust. In terms of private initiatives, I feel like we're moving more and more in that direction. Basically, what I believe is happening, that we have this trickle-down compliance issue where it's much easier for the regulators to regulate someone like Facebook or Google or Amazon and so on. They're bigger, they have more of a chance to come to them, they can issue an audit or force them to have constant audits instead of fines. They can also put them in the long, complicated, costly legal procedures and so on, even though for those companies, it's not such a big hit on their pocket and so on. But it's easier to regulate them. So once they regulate them, and those companies have to trickle down compliance to smaller companies, and have stuff in their, it's like greater permission UI, right? Or for example, Android might issue more regulation regarding push notifications, or Apple might get even more serious about push notifications and so on. The cookies stuff has, something has to be done with it, because it's right now it's a crazy mess. Nobody really knows what's happening. There's still a privacy directive that should be coming, and right now it's quite confusing. So I believe the private initiatives would also have a rise later. So I think we can expect that, and the best way is to watch whatever platforms, especially the big ones that you're using, to understand what might come next. And they tend to share it beforehand and give you time to prepare anyway. So it's a good idea to monitor all the rules that come from big platforms like Apple, Google, Play Store, Chrome, Google, and so on. Google account has done a lot in terms of permissions and data sharing and so on in recent years, after they had their Project Zero and found some issues with the Google Plus and so on. So I believe there will be more of them. Yeah. Not sure about the rest of the world in terms of privacy laws. Some of them are working on it. But again, it seems like everything is going to get more and more fragmented and confusing, which is going to put the compliance costs way up. My only hope is that most countries will use the general data protection regulation as a basis, and that's going to simplify life a lot, because it could be the de facto standard for most compliance issues around the world right now. It doesn't touch up much on security front, but it gives a good basic framework for compliance with other laws. Okay, so it looks like we've had an hour of our stream, and I'm more or less done. And since there are no more questions that I'm seeing in the chat, I'm going to have to say my goodbyes. And thank you for watching. Thank you for asking questions. That was fun. I would be happy to answer any of your questions directly. We'll ask to share the contacts if you need them. So yeah, stay healthy, stay safe, have fun. The apocalypse is going to pass at some point, so let's hope for that. Thank you.